In the case of Gina Carano versus the Walt Disney Company, or as I like to call it, Gina Carano, America, Star Wars fans, and the law versus the Walt Disney Company, there have been some big updates this week, and we're about to bring you everything you need to know about what's going on, courtesy of our good friend and legal expert, the great Ron Coleman of the Coleman Nation podcast, because as you're about to find out, things are not going the way Disney would like them to, and that's probably a good thing. Renegade Online. Well, folks, welcome back. Another great day here at Valiant Renegade. It's good to see all of you out there once again. And if you are like one of the many watching this video, not yet subscribed to this channel, please take a moment and turn that little red subscribe button to gray. Hit that like button, hit that notification bell, share this sucker out on the social medias, and of course, please do leave a comment before you head out the door today. Make sure to join us every Sunday and Wednesday afternoons now, right here on Valiant Renegade, for the live show. Well, folks, we've got a banger of a topic here. This is a story that started breaking about the time I got on YouTube. Everybody remembers the situation with Gina Carano, who played Cara Dune in the very popular series that launched Disney Plus, The Mandalorian. And it came as an absolute shock to quite a few Star Wars fans. I dare say the majority of Star Wars fans, when the Walt Disney Company announced back in 2021 that Gina Carano is not currently working for Disney and there's no plans to bring her back in the future or thereabout. That was a statement that Gina Carano's contract for any future seasons of The Mandalorian following the second season just weren't going to happen. And it all stemmed from what Disney said were some tweets and posts on Instagram that Gina made that to a lot of folks out there seemed rather innocuous. Whether you agreed with the statements or not was one thing, but did they rise to the level of being so quote unquote contentious or so divisive or so controversial as the Walt Disney Company would have folks believe that it warranted not bringing her back? Arguably, the second most popular character in Disney Star Wars behind Mando and Grogu themselves. Well, we have an update recently because there was a hearing in the very case that started not long ago. A case where Gina Carano sued the Walt Disney Company for, let's call it, wrongful termination. Even though she wasn't exactly an employee, that might be something that most people out there can understand. And in California, there's a particular set of laws that protect people for their political positions when it comes to the workplace. And that's what Gina is going after. But here with us today to discuss this topic, as you can see right here, a Wednesday hearing that just took place, and maybe things aren't going the way the Walt Disney Company has hoped, and that's kind of been their MO recently when it comes to court cases. I also believe that recently Disney dismissed its federal appeals when it comes to the goings-on with the state of Florida, and it looks like this case, maybe not go the way Disney would hope it would. But here to discuss it is our friend, the great Ron Coleman, joining us once again.
Good evening, Valiant. How you doing?
Doing good. Glad to have you here, sir. So let's look at this. This was a hearing that took place in the last couple of days. Disney was trying to get the case dismissed, as they typically do with these things, and none of these have been going their way recently with these high-profile cases. Mandalorian firing lawsuit, how Gina Carano's team and Disney are battling in court. At a Wednesday hearing, a judge expressed skepticism, this is according to The Hollywood Reporter, that the Carano lawsuit should be tossed before discovery is allowed to take place. And they go into some detail. So, Ron, tell us, what does that mean to you when you see this?
Well, a motion to dismiss is a motion that says to the judge, a motion to dismiss under Federal Rule 12b-6 is a motion where you tell the judge, we don't even have to get into this. Even if everything they said in their complaint were true, they wouldn't have a legal claim here. And in Disney's case, what they're saying is we have a First Amendment right of association that trumps whatever interest she might have in expressing her opinion. We don't have to be dragged into the mud just because she has her little fascist, right-wing, hateful nerd opinions.
According to Disney, right?
According to Disney.
Yeah.
And that would actually be, as we've discussed before, that would usually be a pretty good defense. But as you pointed out in your introduction, Valiant, as it is in so many ways, and it is so often, and frequently those ways are legal ways, California is different. And in California, they passed a law. They passed a law to protect communists. And that law said you can't fire someone for expressing his political beliefs. Period.
Yep.
If they interfere with his work, that's one thing. We can talk about that. So Disney's response to that is, this does interfere with her work because she's a big star. And people associate her with the role. And whatever she says, it's not a hop, skip, and a jump to getting to Disney. They're going to say, why does Disney employ such a fascistic, right-wing, hateful, nerd opinion person? And that, frankly, is the defense that anyone in Disney's position would assert. There is a clash here between the Unruh Act, the California law we're talking about, and a couple of other general principles of law. One is the presumption of hiring and firing at will. Now, here you had an employee that's under a contract, but I don't have access to that contract. But putting that minor detail aside, there's the general proposition that you can, if you don't like the fact that someone has a bone in his nose or a swastika tattoo or long hair or short hair, usually as an employer, you have the privilege of deciding how your company will be represented in terms of personnel. California, however, came along shortly after I was born and before you were. And again, in reaction to all the business going on with the House Un-American Activities Committee, and said, no, if people don't want to talk about being communist, or people shouldn't have to worry about losing out by being on a blacklist. We're gonna protect them. And there's something, it's a policy choice. It's a policy choice that California made, and one that it has to live with, even if it's not protecting communists. So the motion says, Judge, we shouldn't have to engage in discovery. We shouldn't have to be. We shouldn't have to go through the expensive and confidentiality violating and all the things that people go through in the civil discovery process, which can really be very annoying and very harmful to a business. And I'll give you, we'll go further into the article and talk a little bit about the judge's comments.
Yeah, and there were some interesting comments, to be certain, in this one. And just to kind of go through what THR has here, a federal judge has signaled that Gina Carano's lawsuit against Disney and Lucasfilm over her termination from Mando will be allowed to proceed as the court considers whether the First Amendment allows private companies to sever ties with employees who publicly clash with their values. And, of course, Disney is trying to bring up the issue that they are a creative company, they're an entertainment company, and that there's been some deference in the past where maybe some of these things don't apply to them. And this is always Disney's thing, right? They want to slap everybody else with First Amendment lawsuits like the state of Florida, but when it comes to somebody challenges them on the same issue, it's like, it doesn't apply to us. So, but U.S. District Judge Sherilyn Peace Garnett, and this would be a U.S. district in the state of California, I believe, on Wednesday pushed back on arguments from Disney lawyer Daniel Petrocelli. Now, for those of you out there wondering, this should be a name that if you've been watching this channel that you've heard us run across a number of times, because Mr. Petrocelli is the same gentleman who was helming the cases against the state of Florida. Didn't go so well. So here we are again. He argued.
I wouldn't blame him. He's doing, I'm sure, he's hitting every mark. He's doing everything he should be doing. He's making the arguments he has to make. The problem is Disney and the law. Just like
exactly. Yeah. In fact, that's why I looked at the title of this video and I said it was probably going to be something along the lines of Disney versus the law. So it's basically what we have. But Mr. Petrocelli argued that the lawsuit, Gina's lawsuit, should be dismissed because the company, quote, has the right not to associate with a high-profile performer on a high-profile show who's imbuing the Star Wars series with views, this is a quote, views it disagrees with that could turn fans away from the show. Now, I'll stop right there and remind folks that the last time we talked about this issue, this case in particular, we had to stop and, of course, remind people watching that according to this, then Disney seems perfectly fine with actors. The lead actor, as a matter of fact, Pedro Pascal, who plays Din Djarin, the Mandalorian himself, on this very same show, making posts on social media, comparing people who support a certain Republican presidential nominee to certain German political parties of the 1930s and 40s, directly referring to them as that, and comparing them to the Klan, and comparing them to the Confederacy. That's okay. That apparently is fine with Disney, and that represents them well, but Gina Carano does not. Petrocelli urged the court.
So let me just interrupt you there, Valiant. I mean, if it weren't for this California law, that would presumably be Disney's prerogative to say it is fine. We do think Donald Trump is an NAZI. We think that whether their assessment of what would turn fans away is correct or not is presumably not relevant. I don't know whether it would never be relevant under the Unruh Act, but in a general employer-employee situation, that's the call that the employer is allowed to make.
Right, it's Disney's prerogative.
After all, Disney has demonstrated for the last couple of years that it is absolutely committed to making bad decisions and misreading its audience.
Oh, look at the Acolyte this week. We had so much fun Wednesday, and I wish you could have made it for that one, even though I know you're not watching it. Man, that show was fire.
Yes, I know everybody was looking forward to Wednesday. That was going to be when the other shoe dropped.
Woo. That was something. But no, you're right. Normally, I agree with you. I mean, it's an employer's prerogative to do things. I just bring up the Pedro Pascal issue because I just want to make it clear that it is Disney's right to make that choice in that sense, what they think represents their company. I'm all for it, whether we love it or hate it. But I just want to point out that what Disney's choice was in that case, just so the audience out there is very clear.
Well, and it may in fact end up being relevant, because if the question is that if Disney ends up defending on the ground that we made a business decision, not a political decision, and I don't know the fine contours of the Unruh Act. I'm not admitted in California. Then the objective question may very well be, do they have any empirical basis for assuming that more people are offended by what he said than what she said? So that could end up being relevant. So your point is 100% relevant, but I just want to keep the focus here on what a unique departure this is from the normal thing because of California's law.
Yes.
I also want to make another point before we get into the judge's comments. This judge is a very interesting cat, Sherilyn Peace Garnett. She is a really, really well-qualified judge. She is a Biden nominee, so you can understandably you could see why you would assume she's not well qualified. She happens to be an African American woman, and that could not have hurt her at all in being considered by the White House. But here's a person who graduated from UC Riverside, an immigrant from Grand Cayman.
Oh, wow. Mm-hmm.
Went on to get a law degree from Harvard, was a law clerk for a federal judge in the Southern District of California, then was a litigation associate at Arnold and Porter, one of the outstanding law firms in the country. Then for 13 years, she was an assistant U.S. attorney for the Central District of California, chief of the General Crimes Section, deputy chief of the General Crimes. Domestic terrorism coordinator. And then she was a judge in California State Court for 8 years. So this is an accomplished person who knows her way around the courts. Mm-hmm. She's a bona fide, accomplished lawyer, and no one should, she should get every benefit of the doubt that she is. And as her comments seem to suggest, she's taking things very seriously. I wish every federal judge in California were as skeptical of big tech and big Hollywood as these comments suggest she may very well turn out being.
Yeah, I thought her comments were very sensible and sober in this. And let's look at some of these real quick here that she made. She says, Judge Garnett says, "I am not convinced that there are no disputed facts." And that was a claim that Disney was making. She pointed to allegations that Carano was terminated to deflect attention from Disney's contentious business decisions at the time, including the company's contract dispute with Scarlett Johansson. Of course, remember that story, people that watch my channel, that whole kerfuffle when Bob Chapek was still there. And for those of you that don't know, that is when Scarlett Johansson filed a lawsuit against the Walt Disney Company. They settled out of court. Rumor has it was for north of $10 million to Miss Johansson. But that was when the decision was made to take the Black Widow movie, the first movie that Disney put out following the theatrical lockdowns with the COVID stuff. And they put it day and date on Disney Plus, and then made it a premiere access movie for $30. You could buy it if you were a Disney Plus subscriber. You could buy it early, watch it. And it was at the theaters at the same time. And Miss Johansson's contract, some of her residuals on that film, she had a piece of the theatrical pie. Well, of course, when Disney did that and put it on Disney Plus, it shanked the theatrical pull that it got, the box office. So that's what happened there. So that's what the judge is talking about. And criticism also of Florida's parental rights and education law, which led to the dissolution of its special tax district. Now, the only thing with that, which I'm not quite sure why that was brought up, because that took place almost an entire year, a little over a year after Miss Carano was released from service by Disney. But that being said, and it goes through, the details of the lawsuit, which we've already been discussing to this point. Nothing that, this is Miss Carano's lawyer, nothing she said was on the show or on the set, which is a point that you and I have brought up about this case before. For Disney to try to tie comments that she's made or her right-wing dogmatic nature, or whatever they're trying to allege here of Gina, none of that. We made the comments, you and I, on a live show and in previous videos. Gina was not the showrunner. Gina didn't write the script. Gina wasn't ad-libbing lines in the middle of the show talking about politics and the Mandalorian. Whatever she did, as in my opinion, as innocuous as it was on social media, it never crossed over into any product or content that Disney produced and put out. And that's exactly what her attorney was arguing today. But Disney says that may not matter. The company claimed that there are broad liberties afforded to private speakers and what viewpoints they choose and don't choose to express, And in a case dealing with free speech rights, the Supreme Court held that organizers of a parade, and they go through some of the stuff we talked about before, some of the examples that Disney cite, and that's basically what we were talking about before. Ron?
Well, there are a couple things. First of all, this article demonstrates its bias. It's pro-Disney bias.
Well, it's the Hollywood Reporter.
Right. Because that may not matter, at least according to Disney.
Mm-hmm.
No. Disney argues it may not matter. That may not matter is an editorial. It's spin.
Right.
At least according to Disney is lost. Now let's talk about the differences here. In a case dealing with free speech rights, the Supreme Court held that organizers of a parade that had this was a St. Patrick's Day parade, in New York, and the message they didn't want to convey was a rainbow message, and they had a constitutional right not to include in the event.
Thank you.
So, if they had said, we don't want your pride association because of, and all the pride association was going to do was do leprechaun dances, okay, and not identify themselves as a message, as a pride association,
exactly,
gay rights, whatever it was. The parade, the message was integral to the presentation, to the speech that the parade was expressing.
The group that was petitioning to get in, right?
Right.
And that was the whole issue.
What Disney is saying is, I mean, look, on the show or on set, I think we have to acknowledge is not going to be the standard. Mm-hmm. There's the show, there's the set, there's the events, promotional events related to the program, there's interviews about the show, all those things. I think it's fair to say that Disney could go beyond the show or on the set. But the position Disney is taking right now, and what is probably offensive to this judge, as it should be, is, do you own her by virtue of having a job in one of your comic book movies? Is this woman now your property such that she can't express an opinion on any matter that you disagree with for as long as she's employed by you? That's a very different proposition.
Yeah, I think that's a great point, Ron. And there's even something in here that I thought jumped out at me as being just outright silly. And they bring up, the actual, some of the quotes that or some of the things that Gina had posted. But she said, Disney said the state can't force employers engaged in, quote, expressive activity like we talked about. And Petrocelli, Disney's lawyer, made apparently this comment during the hearing, which I found just kind of absurd. The messenger is part of the message, he says, and then he posited, quote, imagine she, Gina Carano, made comments that she hates Jews or that there was no Holocaust. Judge, imagine if this woman did something that she didn't do. That's what we're here about today. Like, what? Why would he ask the judge to imagine? Because she didn't do this. That's not what the case is about. But he seems to be, and again, we're reading a pull quote from the hearing itself, and I can't assess the full context. But
well, it's a common device, though, in legal argumentation. It's used by judges and it's used by lawyers as well to posit a hypothetical. Say, if we say that there's no limit to what a person can say when she's not on set or when she's not involved in promotions, do we really have to bear the brunt? These arguments are kind of funny because actually, I guarantee you a very large percentage of employees of Disney in 2024, when I say a very large percentage, I don't mean the majority, but I mean more than zero.
Yeah.
Would say those things. would say those things. He is properly, Petrocelli, he is properly challenging the judge to say, to think about, well, is there no limit? To which the judge is going to say, as you point out, well, that's not this case.
Right.
And I don't have to rule that there's no limit. I have to rule on whether or not this is within the limit.
Mm-hmm.
And we use as an example in one of our early discussions in a panel on this case, Mel Gibson.
Yeah. Mel
Gibson doesn't work in Hollywood anymore, largely because he's a confirmed anti-Semite. It's bad for business, and the studios don't like him, or all the reasons. That seems to be, yes, if I hire Mel Gibson, despite the fact that he is an anti-Semite, I am sending some kind of message about my tolerance for that kind of expression. That's a reasonable argument, but that's not this case. So yes, this judge doesn't have to make a broad sweeping rule saying that under the Unruh Act, anything goes. And that's why she's going to say there probably should be some discovery to find out, is that really why you fired her? Do you really believe, was there really some data that you relied on in making this significant, not earth-shattering, but significant creative and business decision to fire her, which said that her continued employment would turn off audiences? Or are you rationalizing that because what the emails and the texts and the Slack discussions will show is that you said, this right-wing bitch has got to go.
Exactly. And if it goes that far, I'm sure there's going to be a lot of things brought up about, especially I think merchandise sales with Gina, the Cara Dune figure, and because they were extremely popular. I mean, I've got a couple of Cara Dune Black editions up there. I mean, they were very, very popular behind Mando and Grogu. People didn't seem to mind what was going on. I think there might have been a small focus of people that were trying to get rid of her, including many at Lucasfilm. And I think that's going to be coming up in this case if it gets to discovery. But the judge hasn't, I don't think, made an official ruling decision yet. But it seems like they are guiding in this direction because, to kind of close this out, this being Miss Carano's attorney, underscored Disney's First Amendment defense cannot allow it to short-circuit the normal litigation process. Discovery will reveal whether the company violated state civil rights laws when it terminated Carano, he added. The judge said, quote, I don't necessarily disagree with you. So take that for what you will, but I mean, Ron, in your learned experience here, what does it sound like to you this judge is suggesting perhaps at this point? That maybe she wants to hear more?
She wants to hear more. I don't see how you come out of that hearing as Mr. Petrocelli with a great deal of optimism. The judge wants to hear more, and she wants to see some discovery. And, it's really, really important to understand that this is not, if she denies the motion to dismiss, it's not a ruling on the merits. It may very well be that Disney's rights do not Disney acted within its rights in firing her. They may very well be based on a sober and rational discussion of what they perceive their audience to be, or even a drunken and irrational discussion, but that it was really based on audience expectations and sensibilities. But as I said, if they find that smoking gun, that suggests that it was punishment for her not being on board with the woke agenda that is so baked into Disney as an institution, may very well make a very big difference.
Make sure you're subscribed to Valiant Renegade and join us every Sunday at 6 p.m. Eastern for the live show.